Yet another turn in the Baha saga, pitting the high-end resort's original developer against China Construction America. The appellate division of the New York Supreme Court has denied CCA's motion to stay the enforcement of that $1.6 billion judgment to Sarkis Ismirlian and vacated an interim stay granted just last month. The ruling then paves the way for immediate enforcement of the judgment that finds CCA liable for fraud and contract breaches that led to the bankruptcy of the multi-billion-dollar Baha project back in 2015. In the face of this latest development, the Attorney General holds that the government has nothing to fear. Devontae Hanna is on the story tonight.
Senator the Honorable Ryan Pinder is reassuring the public that the Sarkis Ismirlian China Construction America legal battle has no implications for the Bahamian government. He emphasized that the Davis administration is not a party to the case and has no exposure to the $1.6 billion judgment against CCA.
We're not concerned. The government has the mind of Bahamian people first and foremost. Whatever happens, the government has to be involved in the process, and ultimately they have to come to government.
The court's decision is a major victory for Ismirlian, the original developer of Baha. Justice Andrew Barak of the New York Supreme Court ruled that CCA, a subsidiary of China's State Construction Engineering Corporation, committed fraud and multiple breaches of contract that led to the project's collapse. Ismirlian's investment firm suffered an $845 million loss, and the ruling awarded damages totaling $1.6 billion. And while critics claim the Christie administration was involved, AG Pinder shoots the rumors down.
I think at that time the Bahamas government was completely in the right in looking to see if there were other financing opportunities, other capital partners to bring to fruition the development plan that everybody had supported.
CCA previously argued that enforcement of the judgment could force insolvency and disrupt operations at two local resorts, the British Colonial and Margaritaville, currently employing hundreds of Bahamians. The company had obtained an emergency stay to delay enforcement, but that has now been lifted. The judgment also highlighted CCA's financial missteps, including a $54 million purchase of the British Colonial Resort instead of paying Baha subcontractors, which triggered a liquidity crisis. Additionally, the court noted a $2.3 million payment to a management group linked to prominent Bahamian figure as an attempt to influence the government.
Long after the developer had defaulted on its obligations, long after it was clear that the hotel was not going to open, long after when we saw the receivership advance. And so I think the government was well on its firm footing and grounds in the best interest of the Commonwealth of the Bahamas to ensure that the largest single investment that happened in the Commonwealth of the Bahamas was completed appropriately, and had the staffing and the opportunities for Bahamians.
And he assures, as the case progresses, Bahamians will be kept top of mind in any decision made. For the Bahamas Tonight, I'm Devontae Hanna.
Hi there, I'm Corval Pyfrom. Thank you for watching our YouTube page. Be sure to like, comment, and subscribe for all things Z&S.